Appeal is allowed. Item 2. It's partly allowed. Item 3. Partly allowed.
Okay.
Item 4. It's partly allowed. Item 5. Partly. Item 6. It's allowed. Item 7. It's allowed. Item 8. Partly.
Yes.
Item 9. Stands allowed.
9 years in custody.
9 years in custody.
Yes.
Which years? Sir?
22.
This will go to some other way.
22 ta.
Old matters.
Assigned best in high.
Single bench. Dedicated bench. Yes.
No cancellation bail. Memo.
Memo for what?
Cancellation for bail.
Huh?
Oh.
No, you see, you want modification?
No, you want cancellation bail.
Cancellation of bail granted by this court or some other
This
court? Just check it up. Supplementary list, item 10.
Item 10, I prefer passable.
Yes. 11.
Item 11.
Your Lordship, I may be permitted to collect the TCR record.
TCR.
TCR record. File.
Here, name, see, this is here.
Supplementary.
Yes.
Item 12.
May I please? Hear me, Lord. The appellant takes charge, me, Lord, offense under section 376 C2VA of SC/ST PA Act and me, Lord, 448 of the I. But the London Trial Court convicted the present appellant for offense under section 376 IPC, not separated, me, Lord, conviction award in respect of other two alleged. PW1 is the
But you are convicted in all the offenses.
yes, sir.
Okay.
But not separated sentence.
The sentence is available.
Lord, PW1 is the 15 days.
Yes, sir. Item
12, right? Sorry, 10, madam, 10. To be mentioned.
10 in supplementary.
To be mentioned, madam. Here, ballot, case is, because argue, like, ballot. Case where the appellants, the three numbers, they have been convicted for the offense under section 324.
That Vairavi acquitted.
Vairavi and two others have been acquitted. 324, 326 and 307, read section 34 of the Penal Code.
Yes.
But injured, but here the London Trial Court had disbelieved the prosecution case with regards to the role played by Bhairavi, because as per the prosecution case, on the date of occurrence, that is on 28/3/93, occurrence has taken place around 5:36. The case is the accused persons and the prosecution party, they had dispute with regards to a patch of land. And it is stated that PW9, Sarangadhara, he had constructed a wall in the disputed land on that day at 2 p.m. So around 5, the accused persons, in those who are 6 in number, Sarangadhara and his family members, along with some other locals, they came to the spot and there was a talk of words. Because it is further alleged, the accused persons demolished that said wall which was constructed on the same day at 2 p.m.
Yes.
During this occurrence, it is further alleged, appellant number 1, Karunakara, asked his mother to bring a seed.
Vairavi.
Bhairavi. So Bhairavi went inside the house, came with a bottle of acid, handed over the same to Karunakara, or poured it in a mug, which was used by Karunakara by throwing it to Sarangadhara. Again, Bhairavi went inside the house, bring another bottle, handed over to appellant number 2, which was also used. Similarly, again she went to the house, again a bottle that was used by appellant number 3.
Twice she did. Like
Thrice.
She did.
And if Bylot will see the evidence of PW1, 3, 8 and 9, both they are all star witnesses.
1,
3, 8 and 9.
3, 8 and 9. All are injured.
1, 2, 3, 8 and 9.
1, 2.
Bylot, 1, 2, 3, 8 and 9.
The injured are injured.
Bylot, yes. Out of them, 2 persons have received grievous injuries, 2 had simple injuries.
1, 2, 3, 8, 9.
Bylot.
1, 2, 3, 8. Yes.
Because if the evidence will be seen as in the trial, while they deposed before the court, they started with the role played by Bhargavi.
Yes.
And they are consistent with their version. The Bhargavi is the person who had brought the acid and handed over the bottle to the accused persons. So beginning is Bhargavi, which was used by accused persons.
The chain is completely broken. In Bhargavi goes.
Peculiarity of the case is Bhargavi, the role played by Bhargavi has been disbelieved by the trial court. A very strong word, or the word that this horror implication is based on exaggeration and embellishment. When this was the role of Bhargavi was drawn, and court has already reached at a conclusion, the answer given by the court is very peculiar and completely and avoided this question, well, let me see the language used by the court. Page 24 of the judgment, my lord.
Yes,
Page 24.
24, internal page 24?
Internal
Paper-
page 16. Judgmental page 16.
16.
Running page 24.
Yes, 16.
My lord, seventh line.
Yes. In this connection, defense cross-examiner, you,
Now let me go to the evidence of PW8. Got it?
yes.
He deposed in his chief that Niranjan demanded acid from his mother and brought the acid and threw to the face of Sarangandhara, and thereafter Niranjan handed over the bomb to Karunakara. The defense due contradictions at paragraph 4, so and so, so and so. I have already discussed,
I have already discussed.
at the earlier stage how and from whom the accused persons brought acid and what was the role played by their mother, lady accused. Now, that is not the vital point for discussion. As to how the accused persons brought the acid and from whom, but the whole aim is to ascertain if the accused persons, Karunakara, Niranjan, and how do they threw acid to the informant office. That is. So, now the court says, I have already disbelieved, so leave it. Whether they have used
That part it goes from the entire.
but court has not explained under what circumstances, because the accused persons prosecution party, prosecution is completely silent about bringing up any other person.
The acid is also relatable to the place of occurrence.
Well,
Because if you say that the Bhargavi story is not believed, Bhargavi got this acid from the house.
yes,
But the acid was in fact there in the shop.
Well, peculiarity.
There is no occasion for keeping the acid in the house.
Well,
Because obviously because of the.
I am coming to that.
Uh,
Another important thing is, Ballot, when attention of the court was drawn to the fact that all the witnesses are related to each other and independent witnesses are present, why they have been withheld by the prosecution. Court says, answer is, again a peculiar answer, that is, it is the choice of the prosecution to examine the witnesses, my lord,
that is the
and
pat answer of
my lord.
also.
Here, my lord, I'm coming to this is the case of prosecution that we throw a shit to the accused person, prosecution party, and they have received injuries. And the same, in the course of same transaction, accused persons have also received injuries. They had informed the IO, PW10 on the same day, within 4 hours of the occurrence, and they were also sent to primary health center on medical requisition.
That is, I think, DW.
DW1.
One.
IO has also admitted, IO PW10 has also admitted that I sent Niranjan to Bandhapada PSC for medical examination.
115.
115 ballot page. I sent Niranjan to Bandhapada PSC for medical examination, but I did not send medical requisition.
I did not send Karunakar for medical examination.
The medical report of Niranjan is not available in the record. It is not a fact that I sent Karunakar to Bandhapada PSC for his medical examination. It is not a fact.
That stood.
Constable 307, Josiram Hota accompanied Karunakar to. He has completely avoided that.
DW.
The reasons best known to the investigating officer, what made him not to say.
Whereas DW1 says that he examined.
DW1, a doctor, government doctor who was attached as medical officer to PSC, says on 28/3/93 I received medical requisition from police to examine.
Yes.
Kaudakar Joshi and Niranjan Joshi. And Kaudakar Joshi has received around 6 injuries, and the other Niranjan has received around 2 injuries. Here, ballot will see one thing.
And you have given a complaint also, exhibit something,
Exhibit C.
exhibit C.
Well, what I want to say, the story of the prosecution
Hmm.
with regards to assault on Saragadhara by a weapon called Simel.
Hmm.
Another peculiar thing, ballot, which can be weighed in the mind of the court. Another, the prosecution case, they have tried to develop the case by introducing Bhargavi and also assault on Saragadhara, PW9, by a stick called Simel stick.
Hmm.
Simel stick.
Sarangara is PW
9.
from PW 9.
My lord, you will see paragraph 4 of the judgment.
Now, when does it say cement? Whether Sarangara said that he was beaten up?
My lord. That was the prosecution case, my lord. But court has disbelieved the same as an exaggeration because there was no corresponding injury.
See, 109, if you see, para 2
My lord.
is very specific. Para 2, 103, para 2, PW9 statement, examination. She says that accused Hadudev and Karunakar called their mother.
Their mother came with 2 bottles of acid,
Bottles of acid.
one plastic bag.
mug, and Karunakar Joshi
is a
is a
goldsmith
goldsmith.
profession
Bhargavi came to the spot
with
to
aforesaid
the aforesaid property because Karunakar and Hadudev called her.
Niranjan Joshi
Sure.
came with a Sibel's lathi. He dealt a blow with that lathi to my left shoulder, points to shoulder joint. Then he was giving a second blow. Kannu Joshi objected the blow and wanted to snatch away the lathi. As a result, he received the blow of the chest. And that
Lathi.
part has also been
and
disbelieved.
paragraph 4 of the PW9 also. Niranjan Joshi threw a MC11 and went to his mother and asked for the
Acid.
acid.
Because Niranjan threw the acid on my face. as,
Acid. Bhargavi
acid
poured
was-
some acid in a mug and gave it to Niranjan.
3 thar jaiji aschi.
Accused Niranjan threw the acid to my face. As a result, I sustained burn injury on my face, including the eye side. The face of the witness is destroyed and left was damaged due to coercive action.
What I want to say, my lord,
acid I
Hmm.
carried out.
This he has stated in chief. Attention of this witness was drawn in cross-examination that we have
Lathi blow not found by the doctor.
no. So attention of this witness, all the witnesses, panel, because trial court for that reason has disbelieved the evidence of these witnesses with regards to bringing of acid blow by Bhargavi or using that Simel lathi, which is a throw like kontabadi. That has been disbelieved. These 2 things has been disbelieved. But injury on the using of acid has been because they have received injuries. Because PW1, 9, 3, they have received injuries. For which trial court is say, now I will not say because I have already said Bhargavi, the role of Bhargavi is not there. So
It appears to be a free fight. Who is
Yes,
thrown on
yes,
on
yes.
whom, nobody knows it.
Malad. And
Both the
at
sides
this,
is thrown.
what I want my entire endeavor is,
Because one of the accused has received burn injury,
yes, and also
not in the hand.
and also lathi
Yes.
injuries, and also lathi injuries. Well, let me see
Yes,
the
I
injuries.
feel that.
Lathi injuries, abrasions, and the court says with knots. Simel has been used, but by them, they had tried to introduce give the lathi in our hand, but court has disbelieved it. Well, let me see. abrasion size 2 inch into length placed over the medial side of the
DW you are reading.
DW1.
Yes.
Abrasion might have been caused by slide over hard and rough substance. Injury number 1 might have been caused by pinpointed lathi object.
Where is that?
Well, at page 118.
Hmm.
So that is more akin to the
Which part? Which part you read?
my lord, paragraph 3.
Para 3.
My lord.
Yeah. Para 3, yes.
I examined Karunakar Joshi, son of Adhikata Joshi,
Hmm. These are the injuries.
my lord,
And injury number 2 might have been caused
by slide over hard and
over
rough
hard-
substance.
slide over
Injury
hard
number 1 might have been caused by pinpointed
Light object.
light object. So that is civil lathi. And the other, my lord, Niranjan has also received lacerated injury of the size of 3 inch into 1/8 inch scalp, bruise of the size 2.5 inch into half inch placed over posterior side, multiple linear abrasions 2 inch length each placed over the posterior part of the right shoulder, bruise of the size. That we cannot say, my lord, self inflicted. And no cross examination by
PW 9 at para 4 he has said, huh?
my lord.
Para 4 he has said that para 3.
Para Sri Niranjan
Para-
Joshi came with a similar lathi. He dealt a blow with that lathi to my left shoulder,
Hmm.
but no injury in that respect. For which trial court disbelieved with regards to assault by female lathi.
No medical support, huh? No medical support.
Because case is to be appreciated considering the entirety of the evidence, not in a peaceful manner. And that too, my lord, the answer to this query, my lord, trial court has given it very flimsy way that each case is to be decided on its own merit. Why I will consider this injury sustained by the accused.
So this is very important that PW 9 says that he received a lathi injury from Niranjan.
My lord.
No medical reports supports that the trial court disbelieved that part. But on the contrary, the accused has received the lathi injury as per DW.
My lord.
Yes,
Doctor says PW9 has not received any lathi injury.
lathi, that's
No.
right.
But DW1 says appellant number 1 has received
Yes.
four injuries by lathi.
Hmm.
They could have put questions, my lord, instead of my lord, we see question by prosecution to this defense witness. Exhibit A and B are the extracts of my original reports in which I signed as bottom. In fact, I sent the original reports to the police. They could have asked, no, these are the injuries
Yes.
which cannot be possible by cement, this, that, lathi.
Anything they can. Yes, that part is.
They have not, they have taken it granted, but as if they have received the injuries means prosecution has proved its case. Prosecution is to be on the face of, but they are inimical, they are interested, and they are also injured, so to say.
Hmm.
On the face of, when these on the face of it, they could have examined some independent witnesses to corroborate their part, because law is very clear that as because a witness is interested or inimical, he will be their evidence is to be discarded as it is. Their evidence can be given the similar weightage like other independent witnesses panel. But when their evidence is not free from clarity, or their evidence has been partly disbelieved by the trial court, their evidence requires corroboration. That is the view of this court as well as by the apex court.
Right.
And they have also not explained the injuries which was sustained by present prosecution, present accused persons in course of occurrence. Well,
And place of occurrence become doubtful after disbelieving Bhairavi, and C, the exhibit C says the place of occurrence is the shop.
yes, madam. Ballot B C, Exhibit C, paragraph 5.
Hmm.
Ballot, as per that complaint petition, the recital is more akin to the entire case.
It is there here, paperwork nine, huh? Exhibit C करो.
Exhibit C visible भी नहीं थे, clear होने.
Exhibit C करो.
ସେଠୁ ଗଣ୍ଡଗୋଳ ହେଇ ହେଇ ସେମାନେ ଦୋକାନ ପାଖକୁ ଆସିଛନ୍ତି.
ଦୋକାନ
ଆଁ?
ତାଙ୍କ ସେ ଜାଗା ବାଉଣ୍ଡରୀ ତାଙ୍କ ଘର ଜାଗା
ପାଖକୁ ଯାଉ, ସେଠୁ ଗଣ୍ଡଗୋଳ ହେଇକି ଆସିଛନ୍ତି, ପୋଡ଼ାପୋଡ଼ି ହେଇକି.
ଦୋକାନ ନାହିଁ ଦୋକାନରେ ସେ ଗୋଲ୍ଡ ସ୍ମିଥ ନା ଦୋକାନ ନଟ୍
ଦେଖ
ପିକ୍ଚର
ଦେଖ ଅଛି. Exhibit C ଟା ଦେଖ.
Exhibit C देखो. Exhibit C निकालो ये.
ଜଜମେଣ୍ଟ ଦେଖିଲେ କଣ ହବ? କାଳେ ଥିବ କଣ ପଣ୍ଡିତ ନିଶ୍ଚିତ ଅଛି ଏଠି Exhibit C. ନାଇଁ ମୁଁ ଦେଖିଛି.
person came and warned Sarang not to raise any wall and abused him in Peli language, says Sarpanchan. Thereafter, Sarang went to call Ujjwala Naik, Vrindavan Panigrai, Kanhu Charan Joshi, Budu Pradhan and Bipin Bihar Joshi, who came, wanted to intervene that both of them purchased distinct land from the Bhikari Joshi. The accused person did not listen to them. The Bhadralok remained at distance 6 to 7 cubits.
Then Bhadraloks were there. And
Thereafter,
one Ujjwala Naik was there, one Vrindavan Panigre was there.
Yes.
None of them were examined. Only
thereafter,
family members are chosen. Yes, next.
thereafter, the accused person threatened to kill Saranga. Niranjan Joshi dealt a blow with a camel stick on the left shoulder of Saranga. When
One minute.
Niranjan
Where
trying
is
to-
where is एक minute.
trying to give
Thereafter,
a second blow,
एक
Kanhu
minute.
Joshi,
Niranjan trying to give a second blow.
Kanhu Joshi
Absolutely.
protected the
Seamal
state by
stick.
raising his hand, but he
Stick.
received injury at his chest to some extent due to the blow. Karunakar and Hadudev called their mother to bring a acid to kill Sarangadhara. Bhargavi brought the acid. Niranjan Joshi also demanded acid from his mother. Thereafter, Niranjan brought the acid from his mother and threw to the face of the Saranga. Sarang cried a loud morally. Thereafter, Niranjan demanded over the mug to the Karunakar. Karunakar took the mug and went to his mother, who poured the acid in the same mug. Karunakar threw the acid to Saranga.
Yes, we read it. What do you want to say?
Well, he is the present there, the pedo lady is the present there, and he also injured. Pedo lady also.
That we know. But that part of the story, this is the two. What you read, half of it you read it. The Simmel stick blow to Saranga is not believed by the trial court because it was it doesn't have the medical evidence support.
Correct.
And Niranjan and Karunakar brought the acid from the mother who gave it in the mug. That is also not believed. The entire sequence of event, the chain of event, is disbelieved by the trial court.
That the
Give it. Give the complaint. Give it seat. And if you see the exhibit C, para 5, on that day, the day of occurrence, all the accused persons, or the accused persons are Saranga, Umesh, Ramesh, Kanu, Saroj, Bipin Vihari, Antaryami, and Ujjwal Naik. On these witnesses, PW 1, 2, 3, 8, and 9, all they are the accused.
1 to 8 and 9.
And read para 5, armed with a deadly weapon, by means of a stick, Parchi and Tangia formed an unholy alliance, and with the common object in order to assault, intimidate and commit theft under the wrongful gain from them, wrongfully lost the complainant, came from the Bari side of the complainant and accused Ramesh and Umesh assaulted Niranjan by means of stick from his backside, and who was standing in the Bari with the witnesses Ghasi and Sadev, also assaulted him by means of stick on the right arm, right thigh, and causing swelling and injury. And the goldsmith shop,
Right.
and
Yeah,
broke
he
open
is
the
accused
broke,
of shop.
broke
Owner
open the
of
entire
the
door
owner.
of goldsmith shop, and the son of the complainant trespassed inside the shop, and all the accused persons, Karunakar from so that's there, assaulting Karunakar, complained with the. Thus they say that the acid was used.
Yes, my lord. Complainant trespassed into the shop of all the accused persons assaulted Karunakara by means of stick on his left hand, for which Karunakara sustained abrasion on his left hand while assaulting Karunakara, his brother Niranjan and complainant, along with witnesses cited above, who were all along present at the time of occurrence, protected the high-handed action of the accused persons. But the accused persons became more violent and furious, took away 10 tolas of gold and cash of rupees 10,000 from the shop, and leaving the shop, the other accused persons instigated the accused Charu to throw acid on the body of the complainant and his two sons, saying, and thereafter, accused number 1, namely Saranga, alias Choru, brought an acid bottle and threw it over the right side chest of Niranjan. And Niranjan has received injuries on the chest, acid injury. As a result of which Niranjan sustained injury over the right side chest. Thereafter, all the accused
What
persons-
happened to this complaint?
Well,
What happened to this complaint?
the cognizance was taken by the time case. I don't know after
What's
that.
going on?
307, 326 cognizance was taken.
This is the cross version of the accused persons, and it was filed immediately.
And no cross-examination has been made in that respect. This is false that.
The complaint case, and this found support from DW1 and DW2. DW2 says that yes, I
And
was the
DW1
clerk.
said also I examined on medical requisition.
So therefore, this part of the version, which is reflecting in exhibit C, is found support from the prosecution evidence only.
That DW, that is the medical report that proves that the accused person is present there. But so far as my learned senior, whether that proceeding.
We are not on that. Accused persons were there. Accused persons were there, as well as these people. There was a fight.
Right.
And which is the place of occurrence?
Okay.
Whether the place where the construction was going on, or the place or the shop. Because if Bhargavi story is taken out, where from the acid come?
Dispute arises from the boundary wall.
Certificate
Dispute
state.
arises in the boundary wall.
Where
Not
from
in
the acid came?
Acid come in his house.
Who got it?
That the police see that acid from searching the house of the accused persons.
Boniya,
And that shop room might have been nearest of the house.
Might have been, no. You tell us.
Because of
Any
the,
question was put, anything, might,
nothing.
but
because
it
of
will not.
dispute arises, ତାଙ୍କ boundary wall କୁ ନେଇକି dispute ଆସିଛି, ଦୋକାନ କଥା ଆସୁନି dispute ରେ.
Look at this, the narration made in that exhibit C
My lord.
indicates that the fight has occurred in the shop, where generally in the shop, the seats are there, goldsmith shop. And this could be believable, but for the reason that the trial court has disbelieved the story put forth by you, by acquitting Bhargav. And what is the credible story? There are two stories. One story is an incident happens at the spot where prosecution is narrating when the wall was being constructed, and the mother of these accused persons went inside, got the not once, thrice went inside and got the acid, gave it to these people thrown on this. This is the story of prosecution. And what is the story of the defense? Everything has happened. They came armed with lathis and all. They came inside the shop where there is a big fight, and acid was also used. This is their story. And your story, the prosecution story, is not believed by the trial court while acquitting Bhargav.
Bhagrav.
Then their story gets credibility. And that story is also substantiated from your own evidence. For the reason that both PW8 and PW9 says that the injury, the blow was caused by the lathi. That the medical evidence doesn't suggest that at all. On the contrary, DW's evidence shows that these people have received lathi injuries and acid injury. So this is how the story goes. Which story is to be believed?
That part, my lord, merely the accused Bhagravi acquitted in the trial court.
It's not
That is
merely-
what we are saying.
That
There
has
are-
to
That
do
all the proceeding, my lord,
the change of event goes,
But
you know.
trial court has acquitted 3 accused persons. We are not concerned about other 2 because they have been disbelieved because they were introduced at the stage of trial. But why you are insisting Bhargavi? Because Bhargavi is the person, lady, who had brought acid to be used by.
And in the FIR also says
Yes,
Bhargavi
in
was
the
there.
And that has
Just
been
see the
disputed.
FIR. Specific name is there, Bhargavi. See the FIR. Bhargavi's role has been very clearly
Mentioned in
mentioned in the FIR itself. Karunakar Joshi, Niranjan Adikanda Joshi, Jayadev Joshi, Hadudev Joshi, Bhargav Joshi. हठात बाहरी आसी मोर कांथ ना कांथ देवा देउथिबा कांथ को भांगी पकेइले भार्गवी वाज देयर
And bringing up acid is also there. And they have not challenged the acquittal of Bhargavi also.
पेज 39 जसी भार्गवी जसी घर भितर पसी प्लास्टिक ये रे
निरंजन जोशी को धराई देला
धराई देला
निरंजन जोशी सेही एसिडी को धरी सच एंड सच मारी देवा कही
Acid पकाइले.
एसिडी पकेला एवं
खाली चक्कू पुणी थरे
पुणे जोशी को
धराई देला
भार्गवी
Bhargavi has
घर
played
भीतर को
the
जाई
major role
But
in the entire thing.
But that acquittal has not been challenged.
You have not challenged that.
Accept the findings.
That finding stares on the face of
भार्गवी एसिडी आनी देइछि आज पर
That's the main.
गोटे थर भी नहीं तीन थर देइछि सरीला पर आउट थर पकेइछि तेने मगरे How will you explain this? He could successfully create a doubt in your story.
And that is the duty of the prosecution.
Hmm.
Prosecution is to create a story which will compete with the prosecution.
Credible story you have to go and
Which will compete with
the
the
entire
defense.
chain has to be proved by you. And their job is to create a doubt. He could successfully.
The law
create a
is
doubt.
valid defense case when it competes with the prosecution case and putting a court in a dilemma, which is true. And the benefit is always in favor of the accused.
Yes.
ସେ ଅଧିକ ଇଏ କରିବା ପାଇଁ 3 ଥର ଆଣିକି କରେଇଛନ୍ତି ଏଟାକୁ।
ସେଟା ତମ ଭୁଲ ନା, ତମ ଭୁଲ ନା।
ଗୋଟେ ଥର ତ ଏସିଡି ପକେଇ ଦେଇଥିଲେ।
But I expect a written note of submission because this is just to
I'm in halfway and I'll do it.
not to. Solvent heard, written note of submission. Yes.
By written note by next week.
Huh. Then this week is mostly leisure week. Huh. Hmm.
You supposed to file an affidavit or auction. I don't know. They're a good question.
11 supplementary list.
Tuesday, make call so that I can.
Ah, ठीक, no. Then next, 12 से start.
Sorry.
Supplementary over, huh? No. Anybody is ready in that weekly
Number 15.
item?
15. 5 years conviction, my lord. 307 and the injured declared as the Lawrence trial convicted the accused appellant basing upon his 1/6 statement.
Sure. Let us see.
PW 80. If they
Jana?
Mention କରୁଛ?
Yes. See, 161 statement is relied upon. The injured himself is hostile. 307 conviction. Relying upon 161 statement.
Item number 15.
15, just see. That is the case, clear cut. What about the medical evidence?
Medical injuries are there. Rather, the injuries depot that on fell down from scooter, I got this injury. And including who is the eyewitness, PW1, who accompanied with him, who driven the scooter, he also stated that due to falling from the scooter on the road, big factory.
Okay. Let's check it up. Do it.
Let's see one item versus 45, let's see.
Huh?
45,
We'll do it.
small matter.
Evidence of this.
Item 15. May I please your lordship, my lord? Here the present appellant convicted for commission of offence 307 and prescribed punishment 5 years, that is judgment internal page, my lord, 9 paragraph, my lord, 20. The convict is sentenced to undergo rigorous imprisonment for a period of 5 years and to pay a fine rupees 5,000. In default of payment of fine, shall further undergo rigorous imprisonment for a period of 1 year. The substantive sentence imprisonment directed to be set up for
5 years.
Here is a case, my lord. The informant injured is the
which part of
PW 8. Straight away, my lord, come to the evidence of the PW 8.
No, let us see the judgment.
Judgment, my lord. Then, my lord, paragraph my lord, 19 also, my lord, read. That is the, my lord, finding of the judgment.
Paragraph,
19, my lord.
yes.
Sorry, my lord. 16 to onwards. Running page 7, my lord. The evidence of the investigating officer PW9 goes to show that Sibo Sankar Mishra PW1 and Prabhakar Rao PW2 made a statement before him that the accused attacked and the accused also confessed to have attacked for the termination of his service on the instruction of Vidyut Kumar Chakraborty, who happens to be the informant of the
Evidence of investigating
Yes,
officer.
huh. Chakraborty, who happens to be the now informant injured, Vidyut Kumar Chakraborty, PW8, who found fault in his operation of operator, of course, PW1 and PW2 being a junior engineer and phone mechanic separately of telecom
Respectively of the telecom department did
Department
not support the
did
process.
not support that. They made such a statement before the IO when they are confessed with their statement. But at the same time, I am unable to accept that the IO recorded such statement to the PW1 and 2 out of his own imagination. On the contrary, the evidence of the IO go to show that PW1 and 2, including PW8, informant injured, for some extraneous reasons, wanted accused to be escape punishment, my lord. And so they did not implicate him in commission of the offense. That means, my lord,
Purely-
eyewitness PW1 and 2, and so also the PW8 informant injured not supported this case, my lord. This is, my lord, surely a travesty of truth committed by PW1, 2, and also 8, my lord, who deserves to be deprecated and described in dealing with them by disciplinary action in such as they are not illiterate laymen or men to strive. They are employees of in telecom department. They hold responsible official position. Therefore, I consider it is appropriate to direct the authorities of their department to deal with PW1, 2, and 8 with disciplinary actions they have indulging in injuries and misconduct in connection with the act of the PW1 of not supporting the prosecution case, in spite of the fact that the incident had taken place when he was carrying PW8 in a scooter in front of the phone exchange gate. He also wrote the report exhibit 3 regarding the incident lodged in the police station. That meant different issue, but apparently, Miller, in view of the paragraph 16, the injured as well as the eyewitness not supported this case. Then Miller come to the petty evidence.
What kind of?
No, that because if your lordship may kind of visualize the situation. The accused was working under at the disposal of the.
That's not the issue. Evidence show me.
No, evidence, the mere the declaration of hostile injured does not. mean
Oh,
that
that's
entire-
the-
Yes,
I can understand if
Yes.
that logic would have been
yes,
followed.
yes,
But the trial court doesn't say. The trial court says proceed against them departmentally because they have not
But-
supported the prosecution. But they have said before the IOs, therefore I am convicting. What is this? logic?
That evidence, your lordship may kind of the 161 cannot be discarded at all. Because injured medical.
Let us see the in the
Yes,
Medical
penal-
evidence is very clear.
let us see.
Corroborating the story of the affair as well as the injured.
I
statement.
can Miller.
143 is evidence actually very clear to leading question when 154 is there.
Touch Miller. Apart from that, all injuries are
So, in that way.
Let us see.
Yes, ingredients of the 307 are not at all, madam.
That's a
Even if the considering the medical
Let us
evidence.
see the what kind of.
Hat Miller PW8, who happens to be the informant and injured in this case. It's a pura Miller. I know the accused. I am informant of this case. In the month of June 1996, I was working as assistant engineer telecom electrical subdivision Baleswar. On 19/6/1996, at about 5 to 5:30 p.m., when I was coming out of Baleswar town phone exchange premises, sitting on the pylon of scooter being driven by SS Panda, who happens to be PW1, one of the staff, I got stroke on the back of my neck, just outside the gate. I fell down from the scooter. I lost my sense. After some time, I regained sense inside the premises of phone exchange and found the staff around me. I sustained cut injuries on my head
It is important.
and fractured on my left side
Colon bone.
colon bone. I was medically examined. I lodged report regarding the incident in the police station. The said report was written by SS Panda. The said report was read over and explained to me. Knowing the contents of the report, I put my signature. That in Exhibit 3 is my report and Exhibit 3 is my signature. I did not know who was the assailant and attacked my neck.
So then he says that I received the injury after falling. And at the same time, there is a assailant also.
No. He said, "My lord, someone attacked on my neck. I then fell down and sustained me. But I did not know who assaulted me."
Okay.
Permit to additional leading questions, my lord.
That is important.
Yes,
I got a stroke on my back of my neck.
head injury received.
Yes.
It is a fact that I inspected the Baripada telephone exchange where private contractor on the order of the department provide generator to operate the machine. The contractor was so and so MS Chatterjee associate. The accused was the driver who was operating the generator on behalf of the MS Chatterjee associate Baripada exchange. Indeed, I found the accused was not properly operate the generator. I had given the instruction of the contractor to give proper training and guidance to the accused to properly operate the generator. It is a fact that the contractor finding the defect in the operation of the generator and that
Terminated the service. of the
don't
accused.
taken my information about that.
I suspected the accused attack on me. I suspected the accused attacked on me on the date of incident out of
Grudge.
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 This is important. I, after knowing the report, marked
No, the
exhibits
report
from
my
263.
activity is correctly written. I put my signature. It is true. Exhibit 3 is not mentioned.
What
that
is written in the exhibit
I
3?
suspected the accused might have
That is a
attacked. Then Milord, out of the accused might be Milord. It is not a fact that I am deliberate the concealing the truth, coming under the pressure of the accused to escape him from punishment. It is a fact that I made identical report to policeman exhibit 3 to my higher authority. Taking the said report into my consideration, my higher authority transferred me from Baleswar to Sambalpur to save my life. That report to my higher authority is not written by my subordinate or colleague, was written by me. My authority accepted report to be true and shifted me Baleswar to Sambalpur. Few months thereafter, I was transferred associate. It is not a fact that I repented that. I did not consider the field as
Okay, good doctor.
But however, Milord, on a fair perusal of the same, he has not seen who actually assaulted to him. Rather, he
FIR is written by him.
PW1.
No,
PW?
FIR Milord written by the PW8.
But he has signed it.
Signed because of that
Read over
condition.
explain to him.
Condition prevailing at that time, he was only signed.
I know the accused and
But the
informant.
affair is very clear and
Let us read
immediately-
PW 1.
I am to inform you that Miller affair on PM, myself, Sri Vidut Kumar Chakravarti, Assistant Electric Engineer, Electrical Television, Subdivision Baleswar, along with J Electrical, Sri Sudhanshu Shekhar Ponda, while going out from the telephone exchange with my office by scooter, suddenly one boy named Sridhara Jena, Miller, attacked me by a koturi on my
Where-
head, shoulder,
where was
left,
studying?
and backside of the backside of neck severely in attempt to murder me. By the time the Jai Swanso Ponda stopped the scooter and saved me with the help of the others present on the spot. After that attack, I fell down from the scooter and my Jai with the help of others saved me. The Jai who wrote the Milord affair,
You read this PW 1?
no, ମୁଁ FIR ଟା ମିଲ ହଜର ପଢୁଥିଲି. FIR ଟା ମିଲ lodged by the
But in the FIR, name is given.
name is given.
Accused name is given.
Accused name is given.
And it's written by Panda, signed by PW injured.
Injured.
Hmm.
To that effect, evidence of the Miller.
And he says, he also says, the injured also says, the report was read over and explained to me. Knowing the contents of the report,
Yes.
I put my signature.
And he specifically also in that report, I fell down from the scooter. And my Jai with the help of others saved me.
Fell down from the scooter, his part is there.
Yes, Miller. I fell down
But
from my
fell down the scooter after the
attack.
Yes.
Then Miller, the evidence of the PW1, no way helpful to the Miller, though he wrote the affair. I know the accused and informant, Vidut Kumar Chakravarti, in the month of June, so and so. In the month of June 1996, at about 5 p.m., myself and the informant so and so came in scooter and B. Chakravarti was sitting on pillar. Then I was coming in the scooter from telephone bhavan to the road. I fell down to a site. Fell down to a site on the road. Also, the informant B. Chakravarti fell down to a site. In the meantime, the informant raised hula. I saw he was surrounded by some persons. He was comforted by applying water and the spot and removed to telephone bhavan. I don't know anything more regarding the incident. Milord, he categorically in his evidence emphatically stated regarding the Milord falling from scooter, he as well as the injured. Then Milord, in that respect, witnesses Milord other also relevant before whom Milord seizure has been Milord effected from the accused, and so also Milord at that present time not only this Milord PW1, other witnesses are there. In FIR, the informant also Milord categorically stated that he saved his life by the help of the PW1 as well as other some persons were gathered after the incident, and they all are declared hostile. And to that effect, my lord, straight away come to the evidence of the PW7, doctor. Medical report, I examined Vidut Kumar Chakravarti Swansu, he was working as assistant engineer, telephone Baleswar, and
I found following injury, 3 injuries.
One lacerated injuries on the left side of scalp placed Miller above the outer margin of the left right of side so and so, bone deep with Miller trace tried blood. Then one lacerated. Then Miller swelling on the left clavion, the junction
Neck injury, yeah.
left. The junction of the lateral 1/3 and of the side so and so. Then Miller, a linear
First injury is head.
Miller,
Yes.
Third, first injury is head.
head,
This is
then
neck.
neck,
Third
and
is-
then is the third hela, a linear swelling contusion on the right side of the neck, oblique plus of the side and so on. Then Miller, all the injuries are caused by head and blood object. Though, as if for a moment, for the sake of argument, admitted the FIR version is true. But the doctor opined that all the weapons, are the head and blood object with a narrow edge of the duration of the injury so and so. And look into the cross. I examined the above injured and put out patient by the time of my examination. There was bleeding from the injury. The nature of injuries, possible by fall.
Yes.
And to that you can look into the exhibit 2, the opinion of the doctor, Three injuries, and all three injuries are
Exhibit 2.
exhibit 2. Laceratory injuries, nature of injury simple. Swelling on the left side, nature of injury simple. A line of swelling, confusion, nature of injury is simple. All three injuries
Nature
are
of injury, simple. Exhibit 2.
two. And more, apart from this evidence, there are other independent eyewitness of the occurrence. They have not supported the prosecution.
I saw that.
That is PW2.
Two things are coming against you. One is the injured is at his instance the FIR was registered, where she has narrated everything and taken the name of the accused.
Yes,
In the cross examination also, he says that I suspect that this accused has given me the blow.
Suspicion. Can a person?
This
Yes.
evidence, though hostile,
Yes.
should corroborated with the evidence, medical evidence.
On that score, my submission is that can a person convicted only basing upon suspicion? He did inform victim
But
injured.
he has, at his
Can-
instance only the FIR was registered.
Yes, he categorically stated that he had not seen who actually assaulted to him in in her deposition.
But in the FIR, yes.
FIR is
FIR yes, the so and so. Though at the FIR is not the encyclopedia, at the spur of moment in a horrifying situation, he might have put his signature, admitted. Though explained that, I read over and explained. But at the very same instance, he put his signature. And more so,
When the incident, what time incident happened and what time the FIR? Just see.
19/6
Incident
সেই দিন
5:35
19:35
6:35
2 ঘন্টা ভিতরে এতটা দিয়েছেন বেলা
6 at incident 5.
সেটা কিন্তু সেটা
6:35 PM রে ଦେଇଛନ୍ତି
I'm talking about the incident.
ଏତଲା ଦେଇଛନ୍ତି 19/6 8:10 PM ରେ ଦେଇଛନ୍ତି ଘଟଣା ଘଟିଛି 6ଟା ସେମ୍ ଦିନ 6:35 PM ମାନେ within 2 hours ଭିତରେ
6:35 ରେ PM and
8:10 ରେ ହେଇଛି
FIR 8:10.
2 ଘଣ୍ଟା ବି ହେଇନି and more so for a moment look into the evidence of the doctor. Admitted doctor also in his process the injury might have caused from fall. Apart from that, the injuries are simple nature.
Hey, what about the recovery of weapon?
weapon of cutlery that IU statement.
Recovery. Who is the witness to recovery?
IU
That was declared hostile, The witness
you are
to leading to discovery, 3-4 are they also hostile, And further, as per the injury report, that is not the ingredients of the 307, not made out. Even if for a moment ଯଦି ସବୁ ଗୁଡା simple ଆଉ ତାର ଆସିବନି 307.
The intention is
intention and injury on the part of the body.
vital part of the body.
Neck and head.
Head and neck. Maybe
by a
simple,
Kottari.
but the intention is there, then 307.
intention Miller for a moment se kohchenti tar mu jehetu injured kon karthila gote report submitted regarding his service for which his service termination Miller, but to that effect there is no other Miller evidence. That is the reason.
What goes in your favor otherwise is there are 3 injuries
Yes Miller.
found. And if at all, everywhere he says that when he gave neck blow, that time he
Whether
fell
that
down,
injury
fell down.
causes the eliminate the
It's
life of injured.
It is a case of single blow.
Yes Miller.
It appears to be. If at all it is believed, it appears to be a single blow.
Yes.
One single blow is given, he fell down,
Yes Miller.
and other injuries caused.
Yes Miller.
Okay. So therefore, the intention part may not be there. So
And
it can
whether
be a case. It can be a case of 323. It's not a case of
yes Miller.
07. That to that
Apart
question
from
you
that,
can
whether
modify.
the injury caused to eliminate the life of Miller.
That's what I'm saying. Because he gave one blow. If the story is to be
Yes.
believed, one blow in the neck, nobody has seen. Is a doubtful. But even if you accept that one blow, thereafter he fell down, and the one blow which was given in the neck is turned out to be a simple blow.
Yes.
And if he would have the intention, he would have given repeated blow, or after falling down also, he would have given another blow. Nothing of that sort. Thereafter he fled away, or he remained in the spot. Nothing is coming on to court. After giving the blow, whether he is fled away or not. And the recovery, 27 recovery is not that
Supported by
good
independent
because
seizure witness.
there is no seizure witness. Therefore, it may be a case of 323 at best, not 307. You can bring that rule. Let us see the IO, what IO says.
That let me say oil and
9.
IO9. But if at all Miller, whether a person Miller lodge a affair, they so and so assaulted me. In his evidence Miller, he Miller not corroborated the same and not exactly different story. He also only stated that on that day I received a stroke, I fell down, sustained it. PW9. On so and so, the SI police in Balesar town police station. On that day, I was deputed on law and order duty in connection with the Miller. Connection of visit of Sri B.K. Barado, chairman of Birla Tires. While I was escorting the chairman, I found Miller gathering near Balesar Telephone Bhavan, Assistant Engineer Telecom, Sri Bidyut Kumar so and so, presented a written report to me. That report revealed commission of cognizable offence. I treated the same affair. Pending the registration of the case, I took up the investigation regarding commission of offence 307 IPC. Examined informant Vidyut Kumar Chakravarti and sent him for medical examination. I examined other witnesses. I visited the spot. I seized the weapon of offence and prepared the seizure list. Exhibit 1 is seizure. List 2, Exhibit 1, 2 is my signature. I arrested accused and forwarded him in custody to the court. I examined the other witnesses on receipt of injuries and finding the prima facie case against the accused. I submitted the charge sheet under section 307 of IPC. I examined Sudhanshu Shekhar Ponda. He stated before me on so and so on 19/6/1996 at about 4 p.m. He and assistant engineer informant while coming in his scooter and went out of the gate of telephone bhavan. One did blow by Kottari to Chakravarti. Someone did
give.
blow by Kottari into Chakravarti Babu. Blow Miller, not blows Miller. The informant who fell down on the ground, then we went near him. mm, he had, he said, Sridhara Jena
Dealt
dealt two
two more.
more plots to Chakravarti Babu, and he
No, no,
Srijana dealt two more blows to Chakravarti Babu, and he, along with the shopkeepers, and they others
Others-
caught hold the Siddharjana. Man, in spot he was
Hmm.
caught hold, then handed over to the police
and
snatched away the Kottari
from
from
him
Siddharjana
Sridhara Jena was taken
to the guard room
to the guard room
and detained there.
detained
there.
there. Chakravarti Babu sustained bleeding injuries on account of Kottari blows, and there was blood stain in Kottari. On inquiry at the
Cause of assault.
assault, Sridhara disclosed in the presence all of that on 3996. Chakravarti Babu went for general
inspection.
inspection to Baripada and opined that he was not competent,
Not proficient.
not proficient
Can to do the work.
so the employer terminated his
And the
service.
motive. Here is the motive.
Regin brought Kottari from Baripada Bajar and came to Baleswar so and could not found Chakravarti Babu that day, finding apparently gave no. I explained,
I examine.
examined Prabhakar Rao, PW2. He stated before me at about 5 p.m. I think. All are Milord.
he said a minute detail before the police, but not supported the prosecution. Yes.
So far as the confession before others, that has not been Milord sustained because nobody Milord supported in case of the prosecution during course of trial. Only Milord here apparently
How many years you have undergone?
Milord
Undergone period?
undergo clear near about 6 months.
6 months.
Because-
Just check it up. Check it up 6 months. Duty. FIR and exhibit 2. Because,
Moving to things,
Exhibit. huh?
period of undergone, I take in person.
Just tell me. We can convert it to 323.
The motive is very clear. If a person is negligent duty and some of the officials.
Where is the evidence?
Hey,
Except
merely
before
because-
IO, who has
Hey,
said that?
merely because the witnesses turned hostile, that not entirely cannot disbelieve this prosecution story.
No, we am not, therefore 323. I am not disbelieving.
Uh,
Partly I am
the evidence-
believing.
The evidence, the statement, the affair story, the part of injury, attack on the body and the medical evidence, both are corroborated. The weapon offense used and this, all the witnesses.
Weapon of offense in FIR it is not said.
Kottari,
FIR does it say Qatari?
let's receive from the spot, the Kottari was recovered.
That is not believed by, that is not supported by your
Hey, affair receipt.
Caesar witness.
Affair ko Siddhara attacked me by Kottari.
See, everything you can't, depend upon the IO statement. Caesar witness has not supported the case.
That's why I've also.
Who has supported? Nothing.
No, the testimony.
If you see very carefully, it may lead to acquittal. Carefully just see, let us read once again. It may lead to an acquittal.
No,
Benefit of doubt, there is a doubt.
doubt in doubt in part
And
of
if
the
you,
attack.
for the time being, if you take out the evidence of IO for the time being, what else is there? You are drawing everything from IO only.
No, doctor's evidence is clear. The affair, if you will be corroborated the affair, description injury part on the part of the body.
Doctor says, doctor found 3 injuries. All the injuries are simple in nature. One is in head, one is in neck. Okay? And 3 injuries the injured himself says nothing about number of injury. None of the witnesses have
Hey,
said
that,
how many blows are given.
that your lordship knows that the sometimes the how the witnesses become too hostile.
That apart,
Circumstances must be
that
foreseen.
I know this is one of our witnesses. That's
And
the
then not only 1 hour, but also threat perception is there. A person but working in the.
But the reasoning of the trial court is completely not acceptable.
Merely because the declaration of injured witness hostile does not.
Completely,
automatically disbelieve the entire prosecution.
Trial court goes on to say that let there be a departmental proceeding because they have not resolved.
Why the trial court ventured to that? Because of knowing very well that witnesses, those are eyewitnesses also, being they are not came into the rescue of the officers who are at their life is at stake.
Yes, you are
That
right.
is the problem. If that would be the trial court would have shot his eyes to that, then you because trial court while examining the witnesses is very examine the posture and this gesture, everything has to be looked into.
The demeanor has to be seen.
Yes, that's why the trial court has observed that and found guilty. The testimony of a witness is not entirely washed up or discarded. The court look into the diamond of rubbish, doctrine of diamond of rubbish there. Yes, Supreme Court or some of the 1 or 2 judgment is there also. Use that.
And FIR also says one injury in Qatari. And the Qatari was seized, then it was not put to the doctor also. It should have been put to
That
doctor.
may be the defective investigation, something otherwise. But Qatari was seized, injury was sustained, and the motive and intention is clear because a person in deficiency, negligent duty, someone is given caution and to threaten, then he will be try to take away the life.
And the motive, where
How
from
the-
you got the
how-
motive?
how-
Where from you got the motive?
Then the statement, other 161 others are there.
Again, IO.
And
Other,
that's why the one on 143 evidence act, when the cross examination leads in the case of 154, the entire things cannot be
for
taught.
confrontation purpose, it's all right, but very difficult.
That weapon of offense also not
I-
meant
I-
for chemical
just-
examination.
Just very short class, para I am just placing my lord.
Mm.
1996 10 Supreme Court man, very short para.
Mm.
Hostile witness, source of evidence of which is consistent with the prosecution or defense case can be accepted. Fact that they resile from their earlier statement under section 160 without giving any reason as to why the investigating officer would record the statement of 161 incorrectly raises doubt. Here is something otherwise. Their subsequent version in favor of the accused. The evidence of hostile witness would not be totally rejected if spoken in favor of the prosecution or the accused, but it can be subjected to close scrutiny, and that portion of the evidence which is consistent with the case of the prosecution or defense may be accepted. The
That's
fact
the
that-
fundamental principle.
Fundamental thing.
So that basis,
Which
what-
portion then? Which portion should we believe?
that attack by Qatari as the affair story is one thing,
Qatari recovery is not proved by you.
but it has not been discarded.
Not put to the doctor also. If it was seized, it should have been put to the doctor, it should have been shown to the doctor.
No, that
Chemical examination report 9.
chemical examination is. If the injured witness has turned hostile, the
Not only
prosecution can
because
still
injured witnesses,
still
all
have a
implicated witnesses also
still win the
declared
case if the
hostile.
other
Who is
credible
Caesar
evidences
witness?
are
Let
there.
us see Caesar witness.
All are hostile. Even if for a moment
Yours are
injured
visual
hostile,
situation. All the
informant
witness-
hostile, then this is a different thing. All independent witnesses all are declared also hostile. And to that effect, PW2, PW3,
Who is Caesar witness? Caesar witness is PW5.
I did not see any incident. Please, Miller, also. I don't know regarding the incident on which recognition is. Said Jena was removed from his job. And apart from that, Miller, how the prosecution came with a case, on the base report of the informant come injured, the service of the present appellant has been terminated, and there is no whether Miller termination letter is there, exhibit whether the Miller the report of the inquiry report of the informant come injured is Miller exhibited in this case. Only Miller have created a story that this being the story reason behind the incident. How if the prosecution Miller came forward with this story, whether there is any link. Apart from that, in 313 question, when Miller while asking me such a question, I move again ଏଥିରେ ମୋ ଚାକିରି ଯାଇନାହିଁ 339 completely denied ତାଙ୍କ ରିପୋର୍ଟରେ ମୋ ଚାକିରି ଯାଇନି
Yes.
I'm custody more than 4 months, 133 days.
Yes.
Also prove the argument of the in that line also.
You have.
Recent is 2025, one of the judgment, the line of the our High Court.
4 months undergo, no?
Yes.
Merely
will
because
also
the
not-
witnesses turn hostile does not
That is the
necessarily mean
general
that
finish.
where evidence has to be thrown out entirely and what is the supportive prosecutions certainly be used. In Gangadhar Behera, State of Odisha, 2008 SCC. Then that is short note, I will be.
I also will not file this.
Relevant reason, both the councils to file the written note of submission.
By next date, I will.
ଆଉ 5 ତାରିଖ ଦିନ
And-
ଦେଇଦେବା ତ
Sorry.
ଆଉ ଡେଟ୍
Give written note.
Yes, and my specific question, case Miller, all the injury not caused Miller to eliminate that is not sufficient to cause the eliminate the life of the Miller injured, for which the under section 307 Miller not made out. Though at all the Miller, it's a case, my Lord Miller point that 323 others Miller, it's a 24 Miller, but 307 not, the ingredients of the 307 not fulfilled, even if the medical evidence. Relying on the Miller injury to exhibit.
Yes. You have one matter, na?
Yes.
Which one?
Obliged.
45, that's it. Item 45.
Big matter, small?
Problems. Simple. Condition 2 months.
Already on 15 days.
15 days. One of the
One is,
died.
first one is died,
Died.
45, huh?
45.
Yes.
323. Understood, sir?
Convicted under 323.
Yes.
Is it about Louis 61 years, P 4, 5.
How many? How
59,
many of them are
48 years.
convicted under? For 2 months, Tulsi Saw. Yes. 1,000. How many acres Tulsi Saw? How much Tulsi Saw has undergone for?
Around 15 days, Lordship.
15 days.
15 days. They are arrested, Lordship. 3 of them, appellant 1, 2, 3 are arrested. For 15 days, after that 15 days.
One means Vishnu Saw,
He died.
Ingra Saw.
Died, Lordship.
Vishnu Saw
Died.
Died, Lordship.
died.
Died.
When?
Died. Report is,
Report is there. Abated already?
yes,
Abated. Very rare. Where is the report? Report you have not given. Only Vishnu Saw died, huh?
Yes.
Take the reports. London Council for the State has produced a report dated 29/7/2025 issued by OIC Belapoda PS in India stating that the stating that the accused Vishnu Saw is son of late Kartik Saw has expired in the year 2021 due to corona. In the absence of any application 394 CRPC by LR or the next friend of the deceased appellant, the appeal qua him stood abated. The report is taken on record. Report taken on record.
So appellant 4 and 5 surrendered on dated 12/12/2006.
4 and 5.
After 5 days, they have been granted bail. Yeah.
4 and 5?
4 and 5.
Only
5
5
days,
days.
only 5 days.
5 days. 5 days. And 3 15 days and 2 also 15 days.
15 days.
15 days. Okay. Shall I give PO?
Yes.
Huh?
Yes, sir.
You PO finish. PO. ठीक है. Appearance here, no? भेज दो. Okay.
Problem.
Thank you.